our presenters are Ms. Brianna Schofield from the Authors Alliance and Mr. Rob Walker from the Berkeley Center of Law and Technology. Please give them a round of applause. All right, let's begin.
Great, thank you. Well, thank you for the introduction, and thanks to Bob Pym for organizing. And we're also just delighted to be co-presenting this with California Lawyers for the Arts, which I know is a great resource for the community. And so we're very pleased that you invited us to be here today. As was said, we're presenting on demystifying fair use. It's good that you guys are paying some attention to the maybe more boring sides of your creative work and dedicating some time to learn about this. So we'll try and make it interesting. We have some examples, some lively examples that we'll bring up, so bear with us. I'm Brianna Schofield. I am the executive director of an organization called Authors Alliance. And as was said, I'm here with Rob Walker, who is from the Samuelson Law, Technology, and Public Policy Clinic. So let us take a minute and introduce you to both of those organizations. Authors Alliance is a nonprofit based here in Berkeley. We're going to be celebrating our 4th birthday this year. So we're a relatively young nonprofit, but we're growing. We have about 1,200 members at the moment. We support authors by providing educational resources like what we're doing today, and also providing some advocacy for sound copyright policy. I encourage you to check out our website. It's authorsalliance.org. You'll find resources, guides, and tools on there to help you manage copyright, answer copyright contract questions. All of our materials we're committed to making openly available online. So we have a series of 3 guides to date. The first that we did is understanding rights reversion. So if you've handed over your copyright, steps you can take to get copyright back. We have a guide to open access, so how to make your works freely available if that's of interest to you under, for example, Creative Commons licenses. And the one that we'll be discussing today is one that Rob and I just completed late last year, which is a guide to fair use. This guide is specific for nonfiction authors, but it's broadly applicable, and it has some overall guidance about fair use and some frequently asked questions. So even if you're not a nonfiction author, feel free to check that out, download it online, and dive a little deeper than we will do during today's presentation. Membership in our organization is free, so you can sign up online, or I have a sign-up sheet here, which you're welcome to fill in after the presentation. I also have stickers and buttons and a brochure and my business card, so take what you'd like, and yeah, feel free to check out our website to learn a little bit more, or stay afterwards to talk to me about it.
Mm-hmm. Yeah, and then as Brianna said, I'm with the Samuelson Law, Technology, and Public Policy Clinic, which is a lot of words, at UC Berkeley. And basically what our program does is we give law students and graduate students the opportunity to engage with real clients on matters of public policy that relate to technology policy. That's a sort of a very broad mandate. We work on a lot of different projects, from things that concern privacy or free speech rights, or the constitutional rights more broadly. We also deal heavily in intellectual property matters, copyright, trademarks, a little bit of patent work, a little bit of trade secrets, a smattering of different things. And the whole purpose of the clinic is to basically provide a voice in the debate that is voices in public debates that are not usually heard, that are either underrepresented in congressional debate, or that don't have sort of a place at the table in litigation or other type of matters. And we've been actively involved with the Authors Alliance since their founding. People from the Samuelson Clinic were involved in the drafting of all of these guides, so there's a nice coexistence
nice
here.
Synergy.
Yeah,
Indeed.
synergy. There we go. Yeah.
Okay, so the structure for tonight's presentation, we will start out by talking about fair use basics. So some of you, well, raise your hands if you're in the room and you've heard of fair use. Okay, and have you heard of the 4 factors, if those of you that have heard of fair use? Okay, great. So we're going to go a little bit in depth into how courts, what fair use is, how courts look at the factors, I'll give a pretty broad overview of those factors, and then we'll spend a lot of the rest of the presentation applying those factors in real cases. You really can get, it can feel quite abstract if you're just listening to the 4 factors, so we'll really try and nail it down and show you how courts have tackled this in real cases. And we're going to do that in 2 parts. First, through fair use in nonfiction, which, as I said, is what the guide is focused on. And then we'll look at fair use in fiction. So we're focusing today on literary works. I'm going to point you to some resources if you're not an author of literary works where you can look for other types of resources. And the concepts are broadly applicable. It's just we can't cover every single topic, so we'll focus on nonfiction and fiction, so literary works today. And then we're going to do some fair use myth busting. So both of us are lawyers, and we hear the common misconceptions, beliefs that are passed around all the time. So we're going to try and clear some of that up. And then we'll take questions at the end. And we've left plenty of time. I know that today we have about an hour and a half. I think we're planning to speak 45 minutes, an hour, so there'll be at least a half hour at the end for questions. I'm happy to stay a little bit later if there's just more questions we haven't got to, but there should be plenty of time. But we do ask that you hold your questions for the end. And those of you that are live streaming, we're going to stop the live streaming before questions so that we'll engage with the audience here in the room with their questions. Anyone who's on the live stream who has questions can send them to info@authorsalliance.org, and we'll try and handle them there. The one thing I will say is we can't answer specific questions about what you are doing and how you're engaging with your work. So we're both lawyers, but in this setting we can provide general information about fair use, but we can't help you apply that to your facts in your case. So what that means is you're going to have to find a way, and you might think about it as we're talking, of how you can frame your questions more generally. And what I mean by that is, and we'll help you rephrase your questions if you can't quite get there. But what I mean is try and think about not asking something like, I'm writing an autobiography about Marilyn Monroe, and I want to use this particular image and put it in my book, and I'm going to say this about this. Is that fair use? We just can't provide legal advice in this type of setting. So think about asking a question more generally about, in what circumstances might it be okay to use a full photograph in an autobiography? How can you bolster a fair use case? Things like that. Again, we'll try and help you if you're having a hard time reconceptualizing it, but try and frame it more broadly. And it'll also help the rest of the audience if you frame it more broadly. It'll just be more applicable to other people. Yep, so that's it. So no legal advice, questions at the end, and we'll get started. So fair use basics is where we're starting. I saw, maybe half of you have heard of fair use, and most of the half of you that have heard of fair use know about the 4 factors. So that's where we're going to start. So you probably know that these days copyright protection applies automatically. You don't have to do anything. You don't have to register your work. You don't have to put a copyright notice on it. Today, that protection is automatic, and the copyright law protects your work in part to incentivize creation. So the idea is that as creators, you need to be able to exploit your work for a certain amount of time in order to create, in order to have some motivation to create and reap some rewards from doing so. But there needs to be some safety valves in that. And so when Congress was looking at the Copyright Act and looking at providing that protection, there are a few safety valves to prevent that protection from getting in the way of onward creativity or things like free expression. And fair use is one of the most important safety valves for that. So fair use allows other people to engage with copyrighted works without permission, without payment, without a license, in certain circumstances, not all circumstances, but in certain circumstances that we deem important enough to allow other people to engage with those copyright protected works. So how do you know what those circumstances are? So in the Copyright Act, there is a section that spells out 4 factors. And those are 4 factors that courts must consider if they're looking at whether something is fair use or not. Courts can consider other factors as well, but they have to focus on, they have to at least consider all of these factors. And they're not to be mechanically implied. So they weigh differently depending on the facts and circumstances. And there's some trends in that, how the courts are weighing these factors, which we'll go into a little bit and you'll see through the cases. But they're not each worth 25%, for example. In fact, some lower courts have tried that, and the higher courts kind of shake their finger and say, no, this is flexible, it's a holistic analysis, you take all the factors together, and you consider them as a bundle, not mechanically. So the 4 factors are as such. The first is the purpose and the character of the use. So this is focusing on how you are using another person's material. So the main question courts are asking here is, have you added new meaning or expression to the work? So the buzzword here is transformative. So have you transformed it by adding new information, new meaning, new understanding? What are you doing differently with this? And certain uses are favored under this category. This is criticism, commentary. You'll see this in the cases we're going to talk about today. News reporting, teaching, scholarship, research. It doesn't have to be one of those things, but if it is one of those things, that helps weigh in favor of fair use. So you put a little coin on the scale in favor of fair use for those types of uses. So if a work is being used for a different purpose than the original, it's more likely to be fair use. But if it's just being used in the same way, if it's just a mere substitute for the original creator intended the work for, it's less likely to be fair use. The second factor that courts consider is the nature of the copyrighted work. So here we're looking at the work that is the original work that's being used in the new work. And here courts consider two main things. They look at whether that original work was creative or factual in nature. So that's one of the things they're looking at. So is it a song, a novel, or something that is intrinsically very creative? Or is it something more factual? And by that I mean something like news reporting or a technical article, a scientific article. And if it's more creative, this factor will be more likely to weigh against fair use. And the more factual it is, the more likely it is to weigh in favor of fair use. This applies to all of the factors, but it's just worth saying again, it doesn't mean that it's not fair use if you're using a creative work. It's just one of the factors that's thrown into the mix. So no one of these factors is dispositive, and that's especially true for the second factor. As you're looking through the history of cases, the second factor is weighed very, very minimally. It's not really a decisive factor in cases. The other thing, so factual creative is one thing that's considered under this second factor. The other thing that's considered under this factor is whether a work is published or unpublished. So if it's unpublished work that you're using in your own writing, this tends to weigh a little bit against fair use. Less so in recent cases. There's been a kind of a trend against this. This used to be a bigger factor, but Congress actually amended the Copyright Act to make it clear that just because something's unpublished doesn't mean it can't be fair use. And why would courts care about unpublished? I think there's 2 reasons that really come through in their reasoning. One is that it's the idea that the author should be able to control when their work is released. So if they haven't released their work to the public, then there's some idea about the integrity of the author's decision in that. And the second factor is just that the author should be allowed to exploit their work and get it out there and release it on their terms. So that's why use of unpublished works is weighs against fair use. The third factor is the amount and the substantiality of the portion taken. This again, you need to think about 2 aspects here. So the first is the amount taken, and this is I think fairly intuitive to understand. The more you take, the less likely it is to be fair use. And in here we're talking quantitatively. How many pages did you take of the book? Did you take the entire painting? That's not to say that it's not fair use if you took the whole thing, but the more you take, the less likely, the more this will weigh against fair use. There's another element of this, so we've talked about this quantitatively, so the actual amount you're taking. The other thing that courts look at here is they look at this qualitatively, and what they often call this, you might have heard, is the heart of the work. Have you taken the most important element of that work and exploited it? A good example of this would be if I'm releasing a tell-all novel and I'm revealing some big secret in my novel, and it might be a long novel, but there's one juicy bit in there, which is why people are buying the book, and you just take that bit of it, that would weigh against fair use because it's qualitatively important. It's the heart of the work. And then the fourth factor is the effect on the potential market. So what courts are looking at here is whether this unlicensed use really upsets the market for the original work. And this ties back to the other factors. You can see how it would play in with the amount you're using and whether you're transforming it. So if your use is really going to supplant the market for the original work, it's less likely to be fair use. So that's a lot. I'm going to say this in a slightly different way because this resonates with some people. A lot of academics and creative communities have really tried to digest these factors and see how they play out in actual litigation and what really we can boil this down to some questions. And this is what these academics have boiled it down to. So did the unlicensed use transform the material by using it for a different purpose or giving it a different meaning, or did it just repeat it for the same value as the original? And that's really the heart of the first factor, and it's quite an important factor. And then the second factor is considering the copyrighted work and the challenged use. Was the material taken appropriate in kind and amount? So for what you are using it for, this ties the amount used back to the first factor. Did you take amount that was reasonable for that? And this does harken back to what I said about sometimes you need to use the full work, and that's appropriate for your transformative purpose, but sometimes you don't. So those two are really interrelated. And again, if you really think about it, those two statements are also tied to the fourth factor, which again is the market harm. The more you're using, the more you're supplanting the original market, the less you're transforming it, the less likely it is to be fair use. So don't worry if this still feels abstract. We're gonna narrow down into some applications of this. But before we do that, fair use is really flexible, and that is a benefit. I know it can feel a little daunting to listen to those four factors and think, well, how am I meant to make sense of that? But it is possible to make sense of it. And one really great resource for doing that is a collection of guides that have been put out by the Center for Social Media. You can look them up on cmsimpact.org. And they've created a collection of guides that are really built with different communities of authors in mind. And what they do is that they do outreach with that community of authors, and they find out the common situations that those authors encounter in their everyday creative lives. And then they build around those common scenarios a set of best practices. So situations and how fair use should apply in those situations, and then some limitations that should apply. So these get a little more concrete than just the four factors, and they're worth looking into. There's about a dozen of these for different creative communities. They started with documentary filmmakers. This is the hallmark guide that they've done that has been really helpful to that community and actually transformed the way that insurance is issued for that community. But there's also guides for visual artists and poets and creators of online videos and journalists and on and on. So check that out if what we're saying doesn't exactly line up with your particular medium of creativity. Those are really excellent resources.
Yeah, absolutely. And so we're going to now sort of, you got all the big abstract ideas here, so how does this play out in practice? So first, here's the tout. we recently came out with this guide here, which is about fair use for nonfiction authors. I like to think that this is actually more, the principles in here are very applicable to anybody who's writing, and I think, you know, would be helpful regardless of the medium. This sort of falls in the tradition of the guides that that Brianna was just talking about, the codes of best practices, but is a little bit different because as opposed to going out and doing interviews with people in a community, what we did was we actually sort of harmonized what a lot of those different codes were saying and tried to draw some sort of meta lessons about that. So I think that that's just, you know, a slightly different methodology to get to something that I feel like has very similar application. You know, this guide also covers fair use basics. So if, you know, you in a few months you go, I remember those people said something, but I don't remember what it was specifically, you can look at the guide. There's also a really nice FAQ section for frequently asked questions that are in the back that are relevant to a lot of different author groups. And the best part about this is a free download on the Authors Alliance site. So you could buy the book in hardcover if you wanted, or you could get it for free, you know, in an electronic version. So anyway, so now applying this methodology, you know, so what are some of the ways that you might make fair use of somebody else's work? Well, one of the big sort of catch-all buckets here is that using copyright material for criticism, commenting, or discussing somebody else's material. You can think about this as sort of the classic way you learned in school to make reference to other works. You know, as if you're writing your term paper and, you know, you say, so-and-so author said this, and then you include a quotation from their work with a page citation behind it. You know, you have copied from their work. Well, why'd you do that? Because you were commenting on it. You were discussing the other work. You were making maybe a critical analysis of this. You know, and this is something that we see all the time and feel sort of very comfortable with in the text situation. You know, oh, I could, you know, excerpt a little bit from the work so I could talk about it. You know, I'm writing a book review and I want to say something about what the author, you know, how the couple paragraphs of the prose I'll include there so you get a sense of the flavor of the style of it, and then I can talk about it again. We feel very comfortable with this in a text circumstance, but this can apply broadly across all sorts of copyright media, including pictures, as we're talking about here. And this is a very a classic case in this area where what happened is that the defendant in this case was an author who wrote a biography and career retrospective on the author Basil Gogos, who was famous for his movie monster posters. And in doing so, what this author did was he copied a bunch of this monster artwork and put it in the book, and then wrote about it. You know, as you can see on the page here, you know, we've got a sort of an analysis of this work. Well, as you can see, he copied the entirety of the image. You know, these were covers from monster magazines, and so he was sued over that by the publisher, saying, you know, you copied our work. And the court come back and said that no, this is a fair use, because what he's doing here is he's paying homage to artistic accomplishments. You know, he's providing commentary. You can't understand the importance of, you know, these images and these, you know, in the context of what the author was doing without seeing them. It wouldn't make any sense. You know, and so in that sense, it was very important. The court also noted that, you know, this is a small portion of the original magazine. You know, the Monsters magazine publisher was saying, oh, you know, they copied the work. And he said, no, he copied the cover, and he copied the cover for a specific reason. He didn't copy the whole magazine. You know, he wasn't making a copy of it to try to sell it, you know, and to supplant the marketplace. This was a specific use. And so you can kind of see in an intuitive way why this makes sense, but then the court is, you know, rigorously applying the 4 factors as it goes through to arrive at something that feels, you know, like the right decision in this case. That, you know, if you're going to talk about something and you're going to talk about somebody else's work, you know, and you're going to do it in a critical way, or maybe you're going to do it in a praiseworthy way. It doesn't necessarily have to be negative, but you just, if you're talking about it substantively, that could be a fair use. So that's sort of one big area where you find it. And particularly for nonfiction authors, this is a really important one. Another place is to use copyright material to illustrate, support, or prove a point. You know, this is a slightly different take on the first one. The first one you have the work itself is what we're providing the commentary or the criticism about. This is more about providing illustration of a larger point or to support something. And the case here, this was a book that was done. It's actually a biography of the writer Richard Wright by the poet and writer Margaret Walker. And what she did was she used unpublished letters and journals that after Wright's death that were controlled by his literary estate, who had denied permission to use these materials. Well, Walker thought that these were important to include in the book because of that this was criticism, this was scholarship. You got a better understanding of who Richard Wright was by seeing the journals. And even though she wasn't talking about them specifically, because these were unpublished works, nobody had read these before, so it wasn't like there was an audience necessarily that was going to that needed to see these to understand her criticism or her commentary on his work. This added additionally to their understanding of the life as a whole. So you can see this is sort of more of a supplemental function to a sort of a main argument. And I've not read this book, but I suspect if you were to go to it, you would see a blending of the first two categories here. There probably are excerpts from Wright's novels, and then there are excerpts from these journals, and then there's a scholarly analysis of the two. And this is sort of how something like this works. It's also really important to note this case because this is one of the first cases where the courts have said, you can make a fair use in an unpublished work. Prior to that, it was not clear that if something was unpublished, but it was still protected by copyright, that it was that you could use it for fair use purposes. This has been, transformative for historians and biographers, particularly of literary estates, because literary estates tend to be highly litigious and really want to control an author's work and sort of their posthumous legacy. And so, for people who want to engage critically with a writer and don't want to wait for the extended term past the writer's death, when this stuff will come out from under copyright protection, which could well be beyond their own lifetime, this is a really important case and a line of thinking and fair use generally. And then sort of the third one we come to, which is the most exciting, at least from a copyright nerdy standpoint. I don't know how many people actually engage with this, but using copyright materials for non-consumptive research. Non-consumptive research is sort of the cutting edge of what's going on in humanities scholarship now. And what it means is basically you're using text as a data set. So if you can imagine, traditionally the way a scholar, say, of the Elizabethan era might, read all of Shakespeare's plays and then, try to draw conclusions about what was going on in Elizabethan drama from having read his plays. Now a scholar might do is they might get every book that was published during the Elizabethan era and scan it into a computer and then use that computer to search for patterns, say words that repeat themselves or phrases that come up again and again. Another example of this, which perhaps even closer to home, is there have been studies done of American writing when you see the transition from the phrase "the United States are" to "the United States is," and you can track the progress of this over time, and what does that then mean as people have conceived of the country in a different way. This is a really kind of, but again, what's happening here is you're taking the entirety of the book. You have to scan the entire book and put it in a database to actually do this. So how is that not a violation of copyright? You copied the whole book. Well, this was something that was highly litigated, again, involving the Google Books project, and another sort of companion project called the Hathi Trust Project. And in both of these cases, the court said that, look, what you're doing here is highly transformative. You didn't copy this book, to use it as a book. You copied this book to create a data set, to create something that didn't exist before. And the fact that you're using it in that way, even though you took the entirety of the substance of the book, that's fundamentally different. You added new meaning or message to this in this work. And so the idea is that, again, we're seeing that the more that you sort of are using something for an alternative purpose, the jargony, a transformative purpose, the closer you get to fair use. It doesn't mean that it's absolutely fair use, but the more you're adding to something, the more that you're getting further along the line to the fair use. And these cases just stand as a great sort of indication of where the doctrine here might go in the future. Is there more uses of work or of text or of video or of audio, in these sort of ways that were not possible without the existence of computer networks and the internet and all these other sorts of things that make this sort of networked and diversified scholarship possible. So this is just an exciting one for again, for the nerds among us who find court cases really fun to read. But again, if you're somebody who's engaged in sort of humanities scholarship at some level, you may come across this term, so that's why we put it in here. So again, the main ideas that we have here, if you're criticizing, commenting, or discussing copyright material, if you're using it to illustrate a point or to support an argument, or you're using it for this newfangled non-consumptive way. These are sort of big categories of things that generally will indicate that this is a fair use. Again, there's no certainty in this, unfortunately. We can't draw bright lines around this rule, but there are patterns, and there are and that's one of the things that guides like ours and the other ones try to do, is to try to point out, if you're within a certain sphere of activity, the chances are better than otherwise that this could be a fair use. So that's sort of a general overview of how fair use is used in nonfiction, and I guess we're moving on to fiction now.
Sounds good.
Yeah.
Sorry. Well,
yep. Jumped in.
Yes, well, when we were preparing for this, Rob says, well, you've got the fun bit, and really I do. So we're going to come out of the ivory tower and the scholarship and research and nonfiction world, and we're going to jump into the fiction world. And I thought this was a fun example to start with. So you might recognize on the left Cindy Lou Who. For those of you who are familiar with your Dr. Seuss, she was the charming child in How the Grinch Stole Christmas. And this has been recently adapted to a stage play, so come with me from the ivory tower down to Broadway. And we'll meet Cindy Lou Who is now 45.
Long ago, you met Cindy Lou Who, whom you saw last when she was just 2. But her life since then has taken quite a strange twirl, for she is no longer that sweet, innocent girl. So see for yourself how she soon hit the skids. But when you come to the theater, don't bring the kids.
See Olivier Award winner Leslie Margarita and Matthew Lombardo's new comedy in couplets, Whose Holiday, directed by Carl Andrus. Begins November 20th at the West Side Theater. For tickets, visit whoseholiday.com.
So as you can see, this is a play loosely based on How the Grinch Stole Christmas. We follow up 43 years later, and Cindy Lou Who is a drug addict and living in a trailer. She's alone at Christmas. And the play sort of tells the story of how she gets there. And she does retell part of the classic Seuss's How the Grinch Stole Christmas. But then she goes on to describe how she ended up pregnant with Grinch's baby when she was 18. She married him. She suffered through unemployment and starvation. Before she eventually ends up killing the Grinch and being imprisoned for his murder. And the play is told in rhyming couplets, so it's similar to the style of Seuss's original. Dr. Seuss Enterprises didn't love this depiction of sweet, innocent Cindy Lou Who, I can only imagine, and challenged this. So this did go to court, and the court analyzed it under the 4 fair use factors. So I thought it'd be useful for the cases I'm going to talk to you about. I'm going to just talk you through those 4 factors. So the first, remember, this is the purpose and the character of the use. In this case, that's the most important factor. So it's the most decisive factor because this is clearly a parody. It's used for a different meaning, different expression. In fact, for parodies, courts say, there's an obvious claim to transformative value. It said, Whose Holiday uses the characters, the setting, the style, the rhyming, everything from How the Grinch Stole Christmas, but it uses it in a really exaggerated way, and it's trying to make the original feel very ridiculous. The vulgar and the distressing subject matters of the play is really intended to be juxtaposed against the utopian society that's depicted in the children's book, and it's doing that deliberately. Again, you can think about the words like criticism and commentary when you're talking about parodies. Parodies are often making a point about that original work in a very exaggerated way. So this is clearly transformative, and that then plays into the other factors. So under the second factor, remember that this is about the nature of the copyrighted work, so the original work. So this is the one factor in this case that did weigh against fair use. But see how it's not decisive. This spoiler alert, this was found to be fair use. The judge says this does weigh against fair use. It's a really creative original work that Seuss did. It's not factual at all. There's these illustrations in it, there's this style and these characters, and he took all of those creative elements, or many of those creative elements, to make this play. So this weighs against fair use. But that, again, was not decisive. The third factor, again, the courts often in parody cases say you took quite a bit, that you took a lot of this work in order to conjure up the original, but in fact, that's okay. This is going to weigh towards fair use because this was reasonable in light of the purpose. So remember how the first and the third factors, I told you they interact a little bit, and this is a good example of how they interact. You took quite a bit of it, but we're looking at whether that amount that you took is reasonable. It's amount you needed to take in order to fulfill your transformative purpose. So that was reasonable. And then the fourth factor, I think this is pretty obvious, but the court went to some great lengths to say that there was virtually no possibility that this is going to supplant the market for the original book. I'm not going to, walk by the bookstore on my way home tonight and see How the Grinch Stole Christmas and think, I'll take my toddler to the play instead. So this is not, they're not going to see the play in lieu of reading How the Grinch Stole Christmas. And in fact, it even went on to say they're not going to read this book, watch the play instead of watching the video adaptation of How the Grinch Stole Christmas. There's just completely separate markets for these. So it didn't supplant the market for the original work or any reasonable derivative work that Seuss Enterprises were going to create on the back of How the Grinch Stole Christmas.
Yeah, and I would just jump in to say that here you oftentimes see the opposite true. That a fair use will actually enhance the market for the original work here. Here I can imagine that if you went to see this play and you said, wow, that was really great. I'm going to go out and buy the Seuss book to give to my kids because they're going to really like this. So there's oftentimes a harmonious relationship between a fair use and the underlying work itself. And that's something you'll see in the cases again and again. They'll say not only does it not harm, it has a salutary effect.
Well, and I'll layer on one more thing on top of that, which is that the opposite could happen. I could go watch this play and decide, actually, this Dr. Seuss is nonsense. This play is right. That's just silly utopian society, and this critique, this commentary that's kind of cutting about it has made me reconsider whether I really want to read my kids How the Grinch Stole Christmas. And courts have explicitly said that kind of market harm from a parody is not the type of market harm that's protected. So if I really cut into a work and the author or the original artist says, you're harming the market for my work because people think less of it now that they've been exposed to the hypocrisy of the utopian society, the courts don't consider that in the market harm. This is maybe a slightly more subtle example of this same type of parody or criticism or commentary. So this is a book, on the left you'll see The Gone with the Wind, a very classic novel. I think it was published in 1936. And in the early 2000s, Alice Randall wrote a book which was based on and critiqued the themes in Margaret Mitchell's Gone with the Wind. And she, in order to do this, retold bits of the story from a different perspective. So the perspective of one of the slaves instead of the perspective of Scarlet and Rhett, thank you. And so, in fact, copied quite a bit of the book in order to do that. So summarized famous scenes, used certain dialogue, used the core characters, used their traits, their relationships, but was told instead from the perspective of, like I said, one of the slaves. It was went from a third-person epic novel to a first-person diary. And in doing so, you'll see the quote I have up on the screen. It wasn't just a general commentary about the American South during the time, but it was actually a specific criticism of the way that the relationship in slavery was depicted in that particular novel. And the court goes on to say, just because she chose to do this through a work of fiction instead of a scholarly article doesn't make the fair use argument any less valid. This is definitely the type of criticism commentary that is eligible for fair use protection. You'll find these factors pretty much mirror what I went through with Whose Holiday, but just to summarize, the first factor, the court found this in favor of Alice Randall. They said it was a parody. It commented on the original work, as I've just described. The second factor, again, it weighs against. It's a creative work that Margaret Mitchell made, but this doesn't matter overall in the overall weighting. It's not dispositive that this weighs against. And parodies, it says, almost invariably have to copy some expressive works in order to do what they're intending to do. The third factor, remember, is the amount copied, and this again is the same. The court kind of skirted around coming to a conclusion here, but they said they don't have enough evidence in front of them to make a conclusion on the third factor. But really, again, this kind of comes down to what I said with Whose Holiday. You have to conjure up a certain amount of the original in order to be effective in your parody or your critique. And then the fourth factor, again, they said this is not going to affect, there's been no evidence this is going to affect the market for the original work. It's not going to displace sales for Gone with the Wind. So overall, this one came out in favor of fair use. So we're going to contrast that. I'm going to give you two examples that are did not come out as fair use. This one is a book by an author going under the pen name of J.D. California, who wrote a book called 60 Years Later, Coming Through the Rye. And it follows a disgruntled 76-year-old man whose name is Mr. C, who's clearly Holden Caulfield from Catcher in the Rye. He escapes his retirement home and he has some adventures in New York, 60 years after the original Catcher. The author did try and argue hard here under the first factor that it was a critique and commentary on aspects of Salinger's Catcher in the Rye, and the court really didn't find this credible. It said, as you see on the screen here, it's the same character doing the same types of things. He was already miserable and disgruntled when he was 16. You haven't transformed him in any way. This is how he already appeared in the original novel. It's not critiquing or commenting on the original work in any way. It's not transformative. So the first factor weighed against fair use here. And then you'll see the other factors kind of fall into place. Second factor, against fair use. It's, again, a creative work. We're in fiction land right here. Third factor, the amount and substantiality taken weighs against fair use, in part because there's no transformative, there's no reasonable in light of the purpose, because the purpose wasn't reasonable to start with. He used a lot of the substance, he used the characters, he used the style of Holden Caulfield, or Salinger, I suppose. So that, again, weighed against fair use. And the fourth factor, again, weighed against fair use. So this is, the court likened this more to an author's right to make their own sequel. So the derivative work right that an author has. So this would harm perhaps not the market for The Catcher in the Rye, but a likely market that the author would exploit, which is a derivative work, a sequel based on their original novel. For those Salinger nuts in the room, Salinger has made it pretty clear that he will never write a sequel to this book, but the court said that doesn't matter. It is still his right to exploit the derivative works. And another one, which was not found to be fair use, these are a series of books called Kinderguides. They actually do write some of these, they're illustrated children's versions of popular novels. Yeah, you guys can see the writing on the wall here. So they do these with public domain works, and that's fine. Once a work is no longer protected by copyright, which in the US it's pretty clear before 1923, a work that was first published in the US before 1923 is in the public domain. So they do this with those public domain works, which is fine because we're out of fair use land. They're no longer even protected by copyright, so you don't have to look at fair use. But this particular set is based on novels that are still protected by copyright. So they retell these classic novels, they strip out some of the adult themes, they make it more accessible to children, they add illustrations, and they add what they call a study guide in the end. So a few like questions to I don't know, I suppose, get your toddlers thinking deeply about the themes in the books. So here the court looked at the first factor and they said, well, Kinderguides, first of all, tried to argue that they were transformative. They're taking out the adult-themed material. They're including the study guides. The court said, no, this is not enough. What they're really trying to do is seeking to fairly retell the original and stay as close as possible with the characters and the plot events, and not adding any new meaning to this. They're trying to be as faithful to the originals. And it's just not enough to call it transformative, doing this retelling in an illustrated format. The second factor, whether it's the nature of the original work, again weighs against because it's a creative work. The third factor, again, weighs against. This is the amount used. There's no hook again here because it's not transformative. So there's nothing for it to be reasonable in light of. It's retelling the story. So in essence, it's taking quite a lot for a purpose that's not transformative. So this weighs against fair use. And like the Salinger case, under the fourth factor, the market for the original work, this actually does disrupt, again, a market that could be feasibly exploited by the copyright owner. This is another what we call derivative work in copyright land, which is these children's illustrated versions are a feasible market that the copyright owner could exploit moving forward. So that weighed against fair use. So that's kind of the gamut in fiction to try and give you some ideas of what courts are looking at as you're engaging with other people's copyrighted works. And we'll do some fair use myth busting, and then maybe in about 10 or 12 minutes we'll open it up to questions.
Yeah, so this is my favorite part of this because you just at least I hear, and again my ears are tuned to this because of my nerdy predilections, but there's a lot of stuff that's thrown out about, oh, that's a fair use, or though that isn't a fair use, and very rarely do these things really track on to what the law says and where the courts have come out. So we just like to sort of throw out some of these general myths that are in circulation and try to make sense of them. So the first one, and this is my kind of personal pet peeve one, is if you don't claim that you own the material, so it's definitely a fair use. I'm sure if you all go on YouTube, you'll see people in the comments, they say, I don't claim copyright to this, but here's a copy of it. It's like, no, sorry, that doesn't work. You don't get to disclaim your copying and then get out of jail for free. Unfortunately, the way it works in copyright is your intention does not matter. It is did you copy the work, and if you didn't, if you copied it, then then that potentially is an infringement unless fair use or some other defense applies.
Can I say something here that we haven't discussed?
Yeah.
This is not the case where you're copying an entire music video and saying, I don't own this. This is more the case where you're, you're trying to engage within the boundaries of fair use, and you're crediting people, you're
Right.
attributing people. This can calm nerves. It can keep people on your side. So it's actually one of the things that comes up in this guide as a best practice. It's not required by law, but as a best practice, giving credit and attributing people goes a long way to keeping the peace.
Yeah, that's right. I mean, I think particularly in the context of a book, if you're working closely with another person's work, the fact that you're giving them proper credit is not only sort of the academic norm and the nice thing to do, but is also a good sort of defense to getting somebody else riled and then making potentially claims against you, even if your work is fair. That's one of the things that I like to say, that being right is free, but proving you're right takes legal fees, and so there's certain things that you can do to both be right and to sort of keep it out of the realm of having to prove it. So that's one. So our second myth. I can't rely on fair use if I ask for permission and permission is denied. You don't have to have permission for fair use. That's the whole point of it. If you think about back to the case we talked about with the biography of Richard Wright, she had asked for permission from the estate. The estate said no. She wrote the book anyway, and the court said that's fine. That's a fair use. Think about any of the parody cases we talked about here. I mean, the Dr. Seuss, the Seuss Enterprises was not happy about this play. Margaret Mitchell's literary estate was not happy about The Wind Done Gone. They're not going to give you a license to make fun of their work or to look at it in a critical way. That's something. So the whole purpose of fair use is that copyright holders don't get to chill expression that may be critical of them just by saying they have a copyright. That's the safety valve that Brianna talked about earlier. If for these purposes that we find important for free speech reasons or for the progress of work, permission is not required. And just because you've asked for it and they denied it, it doesn't matter. Now, sometimes courts have said, that, oh, well, you asked for permission and that shows that there's a good faith to do this within the law and that, you're really being a good actor here. And again, the same thing with attribution. That can be a really powerful tool. If you ask for permission and somebody says, yeah, that's great, go off, use my work, whatever you want to. I would give you permission to copy whatever you want to out of this book, so long as it's attributed. There's that's just sort of the, there's the law, and then there's kind of the common sense nice things to do, and those aren't negated just because there's a legal principle at play. Our third myth: I can't rely on fair use if I'm using unpublished material. We talked about that again. It may weigh against fair use on this, in the factors, but that's not dispositive. That's not going to end it. And there are a lot of places where unpublished materials are really, really important. You can imagine a historian comes across a trove of letters that was written by a notable person, and they want to write about them in a book. That's perfectly fair game, potentially under the law. So that's the third myth. The fourth myth: I cannot rely on fair use. I'm using the entire copyrighted work. We've seen a few examples of this before, but this one we're starting to get into fun thing. There's an actual case. This is Bill Graham Archives against DK, and I can never remember what DK's actually full name is, the publisher. But for those of you who probably know some of these, know of in the room, Bill Graham was the promoter of a lot of the Bay Area music scene in the 60s and 70s, and his archive had this big collection of posters that were used to promote the Grateful Dead. A publisher came out with a book that was an illustrated history of the Grateful Dead and included a number of these posters as art in the book. And as you can see sort of arranged there were other pictures of the band and just sort of this whole tapestry. The court said, this is fair use because even though you copied the entire picture, it's being used for a different purpose. The first purpose was to promote a concert. The purpose here is to provide historical context and to show, that this is what psychedelic posters looked like, or that this was how the band promoted itself, or whatever the book is saying in all of that commentary that's around it. You're showing a timeline of events that's going on, and one of the ways to show it is through these images. So using an entire work can be fair. Admittedly, this is a scary proposition, because they're not. You really have to do the analysis very carefully to get to the conclusion that you can use an entire work. But there are numerous cases where entire works have been copied, and because the purpose behind it and all the other factors line up to say that this is going to be a fair use.
The other quintessential example of this is the Google Books case, which Rob went through earlier, where they scanned not only one whole book, but millions of whole books. They didn't display the entire books, but the copying in and of itself, they copied the whole books, and that copying was deemed to be fair use.
Right. So our fifth myth, I cannot rely on fair use if I'm using a highly creative copyrighted work. We've seen lots of examples of that. And this one we actually kind of just throw in here because the slide is awesome.
Because that's fun.
Right? So, very famous Vanity Fair cover with Demi Moore, nude while she was pregnant, that was being parodied by the Naked Gun 33 1/3 to promote the movie. Here it's a clear parody, and the reason that you have to copy the whole image is it doesn't work as a parody if you don't do that. You'd be like, what? This doesn't make sense. Why is he naked? Why is he pregnant? Well, if you know the original cover and you see how, they have aped it almost exactly. Some people, when they do this slide, they'll put up the Vanity Fair cover first and then fade into the other one, and you see just the match is uncanny, and that was part of the strategy here for the parody. This is also a really good example, is that this is parody. It's referencing back to the original work, but it's also being used for a different purpose. This is not a magazine cover. This is being used to promote a movie, and it's commercial, right? This is the purpose. One of the purposes here is absolutely to sell more movie tickets. So even though fair use often comes up in the context of critical works or sort of things that we might think of as having a real strong public interest or academic function, fair use can also exist in the commercial context entirely, and that doesn't negate the purpose. And then there we go. Exactly. I cannot rely on fair use. I'm making a commercial use of a copyrighted work. And you absolutely can. In fact, most of the cases in the fair use body of law involve commercial uses of one use or another. And this one, the classic example here is this music case, which this one actually went all the way up to the Supreme Court. And so the original, which everybody in this room, I'm sure, knows, is Roy Orbison's "Oh Pretty Woman." The one that probably nobody knows, and there's a good reason for that, is Two Lives Crew's "Pretty Woman." So let me just play both of these for you, and you'll get a sense of the comment on it. I'm not going to play all of it, but you'll have a... So we've all got Roy Orbison in our head now. All right, so now hear the Two Live Crew. And it gets even worse after that. So this in this case, Roy Orbison's, I don't know if it was Roy Orbison or his estate. I don't actually know the timing then. But anyway, the copyright owners of the song "Pretty Woman" said, this is a ripoff. You can hear in that, very noticeable guitar hook that they sampled for the song, the fact that you're using the same lyrics or variations on them, the whole sort of total feel of the song is the same. And the Supreme Court said, yeah, and it's a parody. that what Two Live Crew is doing in this song is that they are commenting on, I believe they were calling it sort of the white bread lyrics of the original Roy Orbison song. I think that was actually in the decision. I can't remember exactly, but that this was sort of a very sort of saccharine pop song that the original was, and then the Two Live Crew version, which if I subjected you to the entire song, the lyrics get cruder and just kind of weirder as they go along. But the Supreme Court was really convinced that this was a parody, and that it was okay because you had to use the heart of the work here. You had to use that guitar riff. You had to use the lyrics and the conceit of Pretty Woman walking down the street in order for that parody to make sense. And this, the reason we put this in here is that this is a clear commercial use. I mean, the whole purpose of Two Live Crew's albums was to sell records and to promote them as a band, and that you can't really frame this in anything else but just sort of a crass commercial appropriation. Yet at the same time, it is absolutely fair use. So again, the big takeaway on this is that any of the individual factors may look really bad for a defendant, but it's about the sum total of them all taken together. And really the second and the third factors are the ones that oftentimes get pushed to the side by the courts if the transformative purpose is strong enough and if the underlying economic rationale is different. And again, the court here was saying that the market for Roy Orbison and the potential market coming out of that is probably not the same market as the Two Live Crew. The idea of Roy Orbison licensing this for a hip hop parody of himself, and not a very good one at that, is probably not. Yes, I have some strong opinions about both of these songs. But anyway, so I believe, does that bring us to the end? Oh.
Yeah. Oh, yes, I'm going to do one more pitch for Authors Alliance. So we're your local nonprofit. We provide tons of resources. I have a sign-up sheet here. I'd really love it if you guys signed up. We're a member-based organization. Members, I think I said there's a free membership level. You receive our newsletters. One thing I really want to pitch today is that Rob and I are actually working on another guide, which will be coming out in the fall, and our members will be the first to know and receive that free PDF. So sign up if you're interested in a guide to publication contracts. Rob and his team of exceptional students are helping us go through publication clauses, talk about ways that you can soften some of those clauses, negotiate potentially for more author-friendly versions, help you meet your publication goals, or just help you understand what the dang thing says. Please feel free to come grab some materials and sign up. You can also join online, authorsalliance.org/join. And I think that we're gonna be cut off and then
Yes.
You're right.
transfer
I'm cutting
to
you
the
off. All right. Thank you all for attending this workshop. For all of you online, please leave a like and subscribe to our YouTube channel so we can provide a full service streaming channel soon. Now, one more round of applause, please, for the presenters.